Few seconds.
Okay, it says it's live.
Okay.
Colleagues, welcome everybody to Business Regulation Subcommittee. We have our chairman and our vice chairman, so we are doubly honored today. It's not just our vice chair beating us down, but we also have the chairman with his whip too. So hopefully we can provide something that's pleasing to both of them. I believe we've done a lot of work. As I said prior to recording, that Laura has done a yeoman's job of taking these ideas and making them, putting them on paper. If you have not had a chance to review, I need you to be quiet, Seth. If you haven't had a chance to review, then we're going to go through it, I guess, line by line. So whenever you're ready, Laura, you want to take over?
Sure. Share screen. Okay. So I guess I'm going to start out by just kind of backing up big picture what the amended bill does, and then we can walk through and see if you have questions for each provision. So the amended bill changes the scope of what's considered an emergency to be just a catastrophic health emergency. The amended bill also limits the scope of who's an essential worker, and it makes changes to the safety provisions of the bill. The bill as introduced contained a separate right to refuse provision. And so now the amended bill cross-references the existing right to refuse standard under MOSH law. The bill has some additional safety provisions, such as the requirement that an employer provides necessary safety equipment, and that an employer pay for testing if the testing is not covered by the worker's health benefits or otherwise provided for free. And then the amended bill requires an employer to provide public health emergency leave in an amount that's up to 14 days for full-time workers and lesser amounts for workers that work part-time. But that is subject to funding provided by the federal government or the state government. The bill lists out the reasons, and it's a more limited set of reasons why someone could take the leave. And then there's a provision that prohibits knowing misclassification of a worker as an independent contractor to avoid providing for the requirements in the bill. The enforcement provisions of the bill have been changed since the last time that you all saw it. So we'll walk through everything, but we subsequently received information from the Department of Labor about how the bill had brought in the right to refuse statute, and the department came back and said that MOSH wouldn't have authority to enforce that because it wasn't changing the MOSH statute. So the amended bill alters and expands MOSH's authority in the MOSH statute to enforce this essential worker subtitle. So an essential worker can seek enforcement of the right to refuse under the MOSH standard. The leave provisions of this bill are enforced by the commissioner generally. There's a separate division of, it's the Employment Standards Service Unit within the Department of Labor that handles leave type issues. So the bill pulls from the sick leave law, the enforcement provisions, does not include the private right of action because that's not covered, that there's no private right of action for essential workers. And then generally MOSH is required and sort of authorized to enforce the safety provisions of the bill. And then there are a number of uncodified provisions, and we can walk through those as we go. But generally, I think the big difference from the last time that we spoke is the Department of Health, in consultation with the Department of Labor and local departments of health, has to develop a template health emergency preparedness plan for responding to a catastrophic health emergency on or before July 1st of this year. And then that the hope is that by getting that template plan, the General Assembly can look at it and see if further statutory changes are needed. If that perhaps should be an ongoing requirement that those agencies coordinate and maintain a response plan. And then on or before October 1st of this year, those same agencies would have to report to the General Assembly on recommendations for potential legislation to enhance their enforcement authority during a catastrophic health emergency. Otherwise, the uncodified provisions are pretty much the same. So that was kind of the high level overview of what the amended bill would do. Does anyone have any questions generally before we walk through point by point?
You got it, hon. Keep it
Okay.
going. You're doing good.
All right, so
Are we going to go back through this now that because I was trying to follow, but so there's a
we're
three.
going to go point by point. That was the overview.
Right.
Okay, thank you.
Go line by line.
Sure. Okay, so this section of the bill as introduced would have required the establishment of a special enrollment period during an emergency. That's being struck from the bill. That some of the health insurance carriers said that that's already allowed. They already have, the health benefit exchange already has the authority to set up a special enrollment period during an emergency. So they recommended that not be included in the bill. This section here, that's been added since the last time you all have seen the draft. This is section 5205 of the labor and employment article, is the sort of the general duty section of law for MOSH that provides for MOSH's enforcement authority. So this says that in addition to any other authority the commissioner may exercise under the MOSH law, the commissioner is required to enforce the occupational safety and health requirements under the Maryland Essential Worker Protection Act.
So Laura, the concern I have there is during a health emergency like we just went through, we're saying that the commissioner shall, but can you imagine how many complaints the commissioner will be getting, and how can he or she, be able to perform the shall part?
So
Part of it is
the,
also, go ahead,
ahead.
Laura.
Yeah,
I was
No, I
just
was
gonna
just
say,
gonna-
part of it is that there'll be a template and
correct. I
that
was
we'll
gonna
have
say
a
that.
plan in place
Right.
to address these
The
things.
plan that we have to have, and again, we're not saying that everybody won't be going through a difficult situation because it's a health crisis. We're just saying that they have to do their part.
So what I'm saying is by enforcing MOSH, that requires a physical visit to the job site. It
It
requires
does.
adjudication, but it also gives the employer the right to react and respond through the administrative law judge, right?
Yep. We'll cover that in a little more detail if you let us go. There's a little more to it than that.
Okay, all right.
well, just for context, we may as well just address it while we're on it. So the amended bill, I mentioned the template plan, and I think the thinking was that this template plan would require the Department of Health, Department of Labor, and local health departments to better coordinate a response so that they would have something that's available to the General Assembly to know, okay, in any health emergency, this is how we want to handle complaints. So the plan has to include a coordinated response for handling complaints related to unsafe working conditions due to a catastrophic health emergency, and the methods for raising public awareness about that process. Because, the subcommittee heard testimony or just information from the Department of Labor that the local health departments were stepping in a lot of cases during COVID. And it seemed that, as you suggested, it may not be exactly clear to a worker where he or she should be calling if there's a problem. So this plan that will be submitted by July 1 of this year should identify more clearly what complaint processes are in place during a health emergency.
And Chris, we're also bringing the health department more involved in this because they have the immediate authority to shut something down without utilizing the court system, which is going to be very important during a health emergency, since they're the health department. And we're not going to rely just on local state department or the local health departments, as the governor spoke about before. We are going to actually focus on the state health department, having them do something beyond kick the ball to somebody else.
Right. I wonder if it wouldn't be advisable to have some discussion. This is uncodified language, Laura.
Yes.
I wonder if it'd be worth it to have some discussion about how larger employers or even manufacturers may seek for some pre-authorizations or pre-inspections that help them come into compliance in a way that once they get certified in that scenario, they're not subject to having dozens of complaints that maybe aren't with just cause. I'm trying to think of it like when it's happening.
Well, and Chris, I want
clear the deck with making sure employers are doing things that they need to do.
And Chris, I want to make sure as we move forward, because we're going to, we can have discussion when we need to, but we're going to be voting on this today. That's why we sent it out this weekend, because we have to get something moving. We can no longer drag this on. We try to bring as much input as we can. And I took a lot of the things you stated and talked about prior to this, as far as that's why we brought the health department in, to make this more concise. There will be no silver bullet, no perfect methodology for this. So if you have specific instances, we can talk, we will vote on them. But overall, I do believe that we're going to be trying to move something out this afternoon by the end of this subcommittee session. And again, it will be on the committee floor. So if there's additional issues, obviously you will have an additional opportunity. And I don't want you to carry the ball by yourself, because I know Seth and Mark aren't here. But I don't feel you have to carry the ball again, because you'll have another opportunity during the committee if there's something you truly have an issue.
We talking about? I'm here.
My bad. I didn't know, brother. But
That's all right.
just to make sure, if there's something you have a true issue with that we're not able to address, and you get your voice, you don't feel your voice is heard, we'll have another chance with the committee. Okay.
Well, I mean, with respect, and I think you absolutely are addressing at least some of the things that Seth and I brought up, and that's important. I'm primarily thinking of it globally as how's MOSH going to enforce the article.
And that's the plan. They're going to have an opportunity to create that plan. That's exactly why we're drafting it, to help them get them to create us a plan of how they're going to enforce it. Instead of telling them how to enforce it, which we've been doing, now we're going to let them tell us how they're going to enforce it by July. That's the goal now. Because I know you brought this up before. That's why I don't want to get caught up around that wheel. That's their job, to tell us how they're going to enforce it. So we're not telling them anything specific. We're asking them, how can you enforce this, get this done, and deal with our citizens in the quickest and most efficient way possible with the powers that you have.
What if they say they can't?
I'm sorry?
What if they say they can't?
Well, then that's not an answer, especially if that's their job. Their job, between them and the health department, Department of Labor, they can do it. That's unacceptable.
Well, I'm not saying that that's their answer, but
Again, we start going on those kind of what ifs, brother, we'll be here all day. We really did take a lot of things you said. That's why we took all that language out about how they need to enforce it, to allow them to say what they can and can't do. And then we'll be the ones to review and say what's acceptable, what's not acceptable. They'll provide a plan to us. Okay. Seth, you have a question?
Yeah. Has anybody talked to the agencies to see if the July 1st timeline is feasible as far as coming up with enforcement actions?
That was my idea, because while we're still in a pandemic, so we need something specific. Again, I know we understand, and once we get inside the committee, of course, the agencies will have an opportunity, but we want to do something in a timely manner, because we have a current pandemic that we're sitting in. So instead of telling them how we think they should enforce this, which is where we're trying to give them an opportunity to tell us, and MOSH already has enforcement. They already know how they do it, as do the health department. We're just asking them for their plan in writing. They already enforce it. They already close down buildings. They already address these situations. We just want their plan in writing. This is not like we're asking them to create something new. They're not recreating a wheel. They've already got it done.
No, I get it. I just want to be sensitive to any type of time frame. That's all.
I got it. All right, keep going, Laura.
Okay. Let's see. So section 5604 of the Labor and Employment article is the department refers to it as the discrimination statute. This is the right to refuse provision of law that sets out, basically in this particular part, it says an employer can't discharge or discriminate against an employee for taking various actions. And then there's that corollary regulation that actually says what a worker has to, or an employee has to meet in order to have a right to refuse to perform a job responsibility. So the amendment here amends that statute to say that an employer may not discriminate, discharge, or otherwise discriminate against an employee because the employee is an essential worker who files a complaint or exercises a right under the essential worker law.
Okay, keep going.
The department had said that the right to refuse would apply in this case anyway, so this wasn't designed to create any kind of new protection. Our understanding is that this is already currently something that a worker would have access to or protection from. This is the section that's struck out on your screen is the section that changed what had to be provided in a pay stub to say information about hazard pay, but the amended bill does not provide for hazard pay, so that's just removing it from the bill. Now we're into the definition section. So the definition of emergency is limited to a catastrophic health emergency as defined under the public safety article. That is the subject of an executive proclamation from that section of the public safety article. Something that one of my DLS colleagues brought up that I wanted to just sort of clarify with you all is it sounded like your intent was to limit this bill to apply when there's a communicable disease, not some other health emergency like a nuclear attack or something that has an effect on the public but is not communicable from worker to worker. And so my colleague suggested that if your intent is to focus on communicable diseases, that we reference that here in the definition of emergency. So I wanted to just make sure I'm clear on what you all are thinking.
Without a doubt, I don't know. And again, I'm sure that committee members have something different, but communicable disease is exactly what we're dealing with here, guys. Not, again, this is not, we're not talking about overweight. We're not talking about floods. We're talking about things to be passed on from citizen to citizen, especially with the unknown variables that we had with COVID. So I think communicable is a very apt word to put in.
Okay.
Yeah, I agree.
Okay. So I can make that change. Thank you.
Please.
This is the definition of essential employer. So it hasn't been changed, and it includes the state and local government. Then as for the definition of essential worker, I did modify this based on one of the prior subcommittee meetings. So the essential worker means an individual who performs a duty or work responsibility during an emergency that cannot be performed remotely or is required to be completed at the work site and provides services that are essential or critical to the operation of the essential employer. There was some discussion that I guess this would be a determination that the individual employer would make as to who is essential or critical to that business or to the employer. And then the reprint removes a reference to a contractor or a subcontractor.
Yep.
Is it pretty clear in that? Is it pretty clear there, Laura, that the employer is the one who is making that determination?
Essential or critical to the operation of the essential employer.
Correct.
Yeah, I mean, I don't think there's no other way to establish. There's no other way to interpret that. Is it the essential?
I mean, that could be, we could tweak it to say that provides services that the essential employer deems to be, if you'd rather say it that way.
Yes.
Deems to be essential
Or critical.
Critical. Okay.
I mean, I think that was the intent of the subcommittee, right?
Mhm.
Yeah.
Mr. Chair, I have a question.
Yes, please.
So what if a business, let's say, instead of using its own employees, chooses to use contractors
Uh-huh.
on an emergency basis? Because, when things like that happen, a lot of
Contractors have a choice. You can't obligate a contractor to come in.
okay, so you're saying the businesses cannot obligate a contractor to come in?
Again, I guess it's open for discussion because we're trying to deal with those that have an employee-employer relationship, because a contractor, remember, in order to be a true contractor, you're the one who defines your hours. You define what you wear, you define when you come and go. So unless they're being what's the word where you're misidentified,
Misclassified.
Right.
they're not a true
Right.
contractor if they don't get to say, no, I'm not coming in. They're the ones who determine when they come in.
Okay, so the assumption is that everyone has the right to refuse if they're contractors.
Correct.
Okay.
Correct.
Well, most law is specific to the employment relationship. I
That's
don't want to
also-
say across the board. I don't know how the most law applies to contractors.
And that's all.
Laura, so the answer to that, Lily, and also Laura, is that a subcontractor and a contractor have a contractual relationship that speaks to performance.
Mhm.
So a subcontractor like me can make a choice to not perform, but then I'm subject to the contract provisions, termination, penalties for non-performance. The nature of that is written in between a contract between two parties.
And unless we want to start getting involved in those contracts and how they're drafted, which I was trying to avoid doing.
And
we were all trying to avoid doing.
no, I think we need to be silent on that. You have
That's why we were moving. That's why I just want to move forward, and we're keeping this an employee-employee relationship, just as most describes it as, or what most covers.
Okay, so relatedly, the next section, 31602, is the section that says which types of employers would be subject to the requirements in the bill. So the way it's currently worded, the subtitle applies only to essential employers in industries and sectors identified by a federal or state agency as critical and responding to the emergency. The subcommittee has subsequently heard from some stakeholders that the language in responding to may be interpreted more narrowly perhaps than you all had envisioned. So you all have suggestions on how we could word that to say that it's not just first responders who would be eligible, but anyone who is, I don't know, that was something I did want to bring up based on feedback we received.
Yeah, so my thoughts on that, if you remember how the governor did this, there seemed to be a tremendous amount of latitude. The governor created, definitions, industries. Unfortunately, some were asked to close, but I think that the last time we met, we talked about trying to include the governor through executive order, having some say in what that actually means.
Well,
And I know state agency gets there, but I think we need to keep the governor in place, not necessarily letting state agencies work independent of the executive branch.
all right. I don't have a problem with. I think we've done it several times where we include the governor or by proclamation. I don't know if I don't think that's a problem to put federal or by governor's proclamation identified, but I think it should be instead of critical during the health emergency or during the health emergency. Instead of responding to, it should be during that are deemed critical during the health emergency.
Yeah.
That would
Okay.
solve that.
Either
Okay.
during or determined critical to remain in operation
Yeah.
during.
During the health emergency.
Okay.
Are you going to let us know what that looks like? I guess we'll come back and see that later.
Yeah,
Yes,
but
I'll send.
most likely she'll send it out tonight or whenever she's ready, and this will be something we'll be voting on in full committee next time we see it.
That's a pretty important one for us, I think.
Which part?
Okay.
What we just talked about.
I mean, that's not gonna. I don't think there's any disagreement. I don't mind
Okay.
checking if it's in there, but there's no disagreement. That's not controversial at all. To make
Okay.
sure, because we've already agreed that we're not trying to have the individual state agencies decide. We want a single person, i.e., the governor, to be the one to decide who, what, where, and when.
Yes.
I think the only reason why I didn't update this provision is, if I'm remembering correctly, the subcommittee said that Governor Hogan relied on the federal list of which industries were critical. So I thought the sort of agreement among the subcommittee was that this covered that, but I don't see any problem in listing out. So it would say as identified by
Which I
The
think
governor
the
or a
governor,
federal or state
federal or state agency as critical to remaining in operation during the emergency.
Correct.
Okay.
What about like a governor's appointee, just because in case, and CT, I'm just you and I as military minds, the governor's appointee, because what if he's, out of play?
We had the state agency.
Okay.
Plus, I think from a legislative drafting perspective, there are assumptions made that obviously it's not the governor, it's whoever is taking his place.
Powers as
Okay. Yeah, I'm just trying to throw in a looking at it from a continuance of government
Got it.
standpoint.
All right, no worries. All right, Laura.
Okay, so the next couple of pages, the language that's being struck was in the bill as introduced, all of the different industries were listed out. And instead now you're saying that the governor or a federal or state agency is identifying which sectors or industries are essential for purposes of the bill.
Definitely.
This section here that's being struck from the bill, this has been struck for several versions of the reprints. This isn't new. The bill had required MEMA, the Maryland Emergency Management Agency, or a local emergency management organization to periodically evaluate whether an emergency is occurring and make an announcement so businesses would know. That's being removed from the bill because the subcommittee had discussed that now the scope of emergency is limited to a proclamation by the governor for a catastrophic health emergency. So you all felt that there was not a need to have a separate agency or making an announcement like that.
Correct.
This section of the bill establishes some additional safety requirements for employers. So during an emergency, an essential employer is required to provide working conditions that comply with applicable safety standards adopted by a federal or state agency. We've removed the reference to physical harm, mental distress, and physical health and safety. The amendment also, oh, go ahead.
I printed it out. Keep going. I think I'm all right.
No,
We're on page 10.
You're looking at the screen. I'm looking at my paper.
Yeah, we're on
I think this is on page, I believe this is on page 12 of,
Nope.
it's on page 10 as numbered,
Yep.
but there are some pages that don't have numbers because of all the amendments.
Yep. At page 10, line 19.
Okay, so the amended bill also requires an employer to provide necessary amounts of safety equipment that's recommended for usage during the emergency at no cost to the essential worker, subject to availability.
Up.
An essential employer is also required to adopt and maintain written protocols to ensure an essential worker's access to information regarding the applicable standards. I think this was actually something Delegate Adams suggested, reworking this so that he has posted publicly, basically just making sure that workers are aware of what standards are in effect.
So if we say adopt, maintain, and make public, or is that what we're trying to get at? Is he trying to say
Adopt and
something?
maintain written protocols to ensure access to information regarding the standards in effect.
Right.
If
So
you'd rather just say post in the worksite, there probably are existing requirements under MOSH law and OSHA, but if there are specific standards for this health emergency, they would be required to share that with the workers.
and I believe that adopt and maintain, and I guess we're getting to what we're trying to get to as far as the posting, make sure that because the goal is to make sure the employers know, ensure that, and worker access to information regarding that. I mean, the only thing is that's legalese, but this is the law. So the intent is that we want them to make sure that the workers know what their rights are during this public emergency, correct?
Well,
Yes.
Is that what you all are wanting?
I think what you're
Yeah.
saying, I think that
Yeah.
covers it. But I think the words you're using are fine because we are writing laws. We don't have to legalese actually works.
We'd rather just say require them to post written protocols, however you want to word it.
Yes,
I like it. I
Adopt,
like it.
maintain, and post.
There
No,
you
I
go.
like it like it is. The way you've got it, it says maintain written protocol. So that the only way to do that is to post it like wage and hour law.
Well, again, just
Yeah.
for simplification though, I think adopt, maintain, and post wouldn't hurt.
What about make available upon request?
Nope. Post, because they're not gonna request something they don't know about. It's kind of with the wage and hour laws and all that stuff. You gotta put it out there.
Okay.
Okay. And then this language here was discussed at the last meeting as well. Essential employers are required to provide or implement any other measures or requirements set by the governor or a federal or state agency to ensure the general health and safety of essential workers.
Yep.
Yep.
This
Good.
next section that's struck is the provision that would have defined unsafe work environment and then set out a separate right to refuse standard. So that's been removed, and instead we are going to be referencing the existing right to refuse standard under MOSH law, but that's not, we haven't gotten there yet. I think I actually scrolled past something else that was struck. This section here that's struck required employers to establish specific plans for their business. And so that is being removed. The underlined language here on your screen just cross-references the existing right to refuse provision under MOSH law. This new section 316.05 sets out the disease mitigation requirements, and these have been limited somewhat from what was in the bill originally. So during an emergency, if an essential worker or another worker has contracted the communicable disease that is the subject of the emergency at the worksite, the essential employer has to take proactive steps to minimize the risk of transmission, including informing essential workers that they may have been exposed. And then the testing provision has been changed. So an employer has to pay for the cost of testing for the specific communicable disease unless the worker's health insurance coverage or other benefits already cover it, or the worker has access to a test free of charge.
Let me go back to the 1605A1.
Yes.
All right. And I know CT doesn't want me to get wrapped around the axle on that, but that was a lengthy discussion we had about my duty as an employer to, number one, identify someone that may have been infected, but also am I in the best spot to articulate a person's health situation? Because I think don't you have to be fairly specific?
Again,
I'm concerned about HIPAA.
I appreciate that. And as we've said for several other communicable diseases, that when time is of the essence and individuals' lives are at stake, are in jeopardy, I understand there are HIPAA rules, but I do believe that it's incumbent upon the employer, if they know that another individual has a communicable disease such as tuberculosis, or in this case, COVID, that they immediately notify anybody who may have been in contact instead of waiting to get wrapped around the axle. I'd rather be wrong on this than miss an opportunity to save someone's life. So if this is something that somebody wants to challenge through the courts, I'd gladly accept that, because the rationale is we're saving lives. This isn't to put people's business out or try to, embarrass people. It's to make sure that you save the lives of these individuals that work for you.
All right, and I hear you, and I don't disagree with you on principle. As me as an employer, should I have known these things? Like if I have an employee who gets COVID because another employee got it, is me as an employer in a position where I should have known that, and therefore I'm responsible for the other employees getting sick?
Well, the way it's drafted, it always drafted it. I mean, and I guess we didn't write it in there, but there's an assumption that you can't convey something you have no knowledge of. So if you're not told that you have an employee that's sick, there's no possible way that you could notify another essential workers that they've been exposed.
So the only way all right, so CT, the only way I would know that if you worked for me and you said, Chris, I'm going to go get tested. I think I got COVID. I've got to go back through the business and inform others who work in your space that they may have been exposed.
Again, if they come back and say they have a positive, then yes. Which is also, we have the leave, the part with the leave in there that says that you have to let somebody know that you have a positive before you take leave. You don't get to say, hey, look, I'm just sick, I want to take COVID leave. You have to provide some documentation. You actually have COVID so they can keep the workplace safe for the individuals that may have been exposed.
All right. Last question.
Sure.
I don't know. I don't think you answered that one in a way that helps me. On the last question, if I inform essential workers that they may have been exposed, does that automatically provide them the right to leave work?
I would imagine they write them or go get tested. But yes, if it's an unsafe work environment, then they get to go get tested. I had to do it 3 different times at my law firm, and pretty much everything stopped. We all drove, unfortunately, to Virginia because we couldn't find a testing place in Maryland. And we drove to Virginia as an office, and we got tested because their lives are more important than the work we were doing.
Well, okay, not every industry is like yours and mine, where we're not necessarily mission critical to services, but you could take some examples where if you had one person test positive that was working within proximity of 15 or other, say, line workers, assembly workers, manufacturing, or food processing, that you could easily see how the way that we've heard this would knock out an entire industry theoretically. In fact, under COVID, probably would have if this had been law.
Without a doubt, it would have. And that, like I said, there's no other way around that as far as protecting individuals. I don't know how we could say, well, let's just keep everything going and let certain people work and certain people stay, because some individuals that may not be, infected may leave, and the individuals that are infected are actually there passing it on to other people. It becomes again, we're talking about communicable diseases, deadly communicable diseases. I believe we have to take that into consideration because it's not just the flu. I understand your point. I understand the whole point of shutting down industry and how dangerous that is, but we have to balance that with the lives of the individuals that are working in that industry. And I want to make sure that they have the protections as well, which is why we have this bill.
All right. Well, I respect your response. That didn't come close to satisfying industry's concerns, I'm sure.
I'm sure. If there's
I mean,
another,
that's the second axle that I've gotten wrapped around here.
sure. No, I got you, buddy. I appreciate it.
I'll stop there. Okay.
No, I appreciate it. Thank you, bud.
Okay.
All right, go ahead, Laura.
Okay, Mr. Chair.
Yes,
The
ma'am.
part I want y'all to go on page that 1520. Go back up. No, I mean down. What am I saying? Down. What this you said, Lord, they gotta pay for the test?
The employer has to pay.
Oh, the employer. Okay. I thought you
Unless-
said the employee.
Essential employer has to pay for the test for the specific communicable disease that is the subject of the order or the proclamation by the governor. So not just if there's a flu or something circulating, the specific disease that's causing the catastrophic health emergency. They have to pay for that testing if, unless there's health insurance that covers the cost, or there is the worker is otherwise able to obtain the test for free. So right now, in the current pandemic, a lot of people have been able to get the PCR test specifically free of charge. So the employer would be required to step in if there's no kind of free option available, or if the insurance isn't covering it.
Okay.
Okay, go.
Yep.
I'm trying to understand it. You can go.
Okay. This section here has not been changed by any of the amendments. It requires an employer to report positive test results to the Department of Health, and then the Department of Health has to take that information. The information has to be specific to certain demographics, but while redacting personal identifying information. And then the Department of Health is required to collect that information and publish it in a format that's accessible to the public. And then the Commissioner of Labor and Industry is required to adopt regulations for implementing that, those requirements.
Yep.
Um,
Go ahead, Chris. Are you worried about HIPAA again?
the employer shall violate HIPAA. Yes, but go ahead.
Now, again, this is.
I think it's a straight up preemption issue, but
Okay, and those are one of those things that the courts will prove us wrong if our intent is good, but I do believe in these times, there's no other way of collecting, this helps collect that data, especially by industry. So I got it.
You're saying I shall report and that the employer shall include information. And I'm saying during the very worst of the COVID environment, Mr. Chris Adams was never required to do any of that. At the same time, I felt like when the opportunity arose to protect a worker, we went out of our way to do that, which I think most employers did, but never would it have occurred to me to violate a person's private information, which is basically what you're asking to do here.
Without a doubt. And I think if we can make things better, and like I said, this is a catastrophic health emergency, a pandemic, last one happened 100 years ago, then I think we should. In cases like this, I believe the good of the people comes before someone's personal, the HIPAA issue. So again, that's something, if we're challenged, we'll deal with it. We can put a severability clause in here if you want, Chris, to make sure this all survives.
I don't think you need the severability clause.
I'm just bringing up issues, my friend.
There's a question about who's actually subject to HIPAA laws, because I'm just seeing that employers are not subject to HIPAA laws, only healthcare providers. So there's that.
It's not that it's more or less me sharing information. That's the violation.
Right. They're not subject to HIPAA laws though, because they're not healthcare providers.
Okay.
Again, yeah, I get you though.
That's the Department of Health. You shall submit to the Department of Health, health provider.
Yep.
Okay.
To them,
Right.
They can't give it back to us.
Okay.
And I will look into that a little more. I made a note for myself to check in about that piece with the AG's office. So hopefully we can get some clarification on, as I'd be interested to know whether there's a preemption issue or not.
All right. Thank you.
Yep.
And again, that goes again, once they disclose it, it's no longer protected information unless you're in a health provider. But okay, we'll keep it moving.
The next section of the bill is the section that
Laura, when you
originally-
ask that question, AG, I'd also be interested in whether the employer can force a worker to provide that information.
And the only time we require them to actually, that we would ask them to or force them to, is if they want to take that leave. Remember? That was the only time. Again, you're right. They can go get the test and they're not going, there's nowhere in this article beyond taking the leave that they would be forced to tell you whether they're positive or not. If they tell you, then you need to turn it over. It's no longer protected under HIPAA because it's not protected information if they tell you. But if they want to take that leave, you deserve the documentation to show that, number one, they have it, and two, so you can react properly with the other individuals that are on your staff. Go ahead, Laura.
Yeah. All right, so the next section of the bill had provided for bereavement leave and health leave. So bereavement leave has been removed from the bill. And health leave has been altered to be called public health emergency leave, which is paid leave that an essential employer must provide to an essential worker during the emergency. There's a scope provision here. I consulted with my colleague down in appropriations because you'll remember this bill is jointly assigned with appropriations because of the impact on public employers, the state and local governments. So this language is intended to make it explicitly clear that the leave requirement only applies if federal or state government provides funding for the leave.
Correct.
That was what you all had discussed at the last meeting.
That's correct.
And then the leave would need to be provided on the date that the emergency is declared, of course, subject to the funding being available. If the funding is provided after the date that the emergency is declared, then the employer would need to provide the leave on the date that the funding is made available to the employer. And then an employer is required to provide the leave.
Wait a minute,
In
go back
addition-
to that 14 days again. What did you do here?
They get 14 days instead of.
I didn't do anything.
It's gonna be 5 days. We made it 14 days. The original in both the vice chair and the chair's bill was for 14 days additional leave that they could qualify for under this public health emergency. So
Or it's just not in this section?
no.
Correct.
So
I
we're
see
getting,
It's farther down, Delegate Turner.
Yeah,
Okay,
yeah,
got you. Go ahead, y'all. I'm following you now. Go ahead.
yeah.
gotcha.
So the next section of the bill is what talks about the amount of the leave that would need to be provided. So the employer is required to provide the paid leave in addition to any other leave or benefit, including the sick leave that's under the sick leave law, and in the following amounts. So if there's a specific amount in a federal program, like we had under the FFCRA, the Families First Coronavirus Relief Act, then the amount that's provided for in that federal law. If not, or not just a law, but any federal program, if it's not specified in any sort of federal program or law, then it would be for a full-time worker, 112 hours, which is 14 days. And then for part-time workers, there's different calculations based on how often they work. This is pulled in from Madam Vice Chair's House Bill 1326.
Okay.
And
And we had discussed that at the last subcommittee meeting.
I'll get with Madam Vice Chair because I'm horrible at math, and I'm sure there will be a question on the floor as if I only work 3 days a week and blah 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 blah. And I'm not going to know those metrics. So Laura, I need you to help me out with this. So
Okay, yeah, no, I'll talk to the advocates and get an
yeah, I'd
explanation.
like to find out what it is, kind of on that kind of part-time, 3 days a week or 2 days a week. What am I looking at?
Okay,
And then the next section talks about the reasons why an essential worker can use the leave. So at the last subcommittee meeting, you all trimmed down, there had been 9 reasons. And so now there's 6 reasons that you could take the leave. I also think that you all made some specific changes to the language. There was references to symptoms in a few places that I removed.
Right.
So this is a lot. Do you want me to walk through it, or do you want to just read it and let me know if you have questions?
That's all brand new.
It's pretty much not, but we can.
Sort of.
Well, I'm
was-
sorry. Go ahead.
We only struck 3 things, but if you want to walk through them briefly, that's fine because
Sure.
the points.
This was in the prior reprint that
Right.
you all received. But the prior reprint had 9 different reasons that someone could take the leave, and you all limited that to 6.
Right.
So
And
the
narrowed
first
down
is,
even some of those. So basically, all but 3 of those are there, and we narrowed each of those down a little bit as well.
so for example, with the first one, to isolate without an order to do so because the essential worker has been diagnosed, or in the second prong, you all wanted that changed, is experiencing symptoms associated with the communicable disease that is the subject of the emergency and is awaiting the results of a test to confirm the diagnosis. That was something specific that the subcommittee wanted to be added. 2 is to seek or obtain a medical diagnosis, preventative care, or treatment because the essential worker is diagnosed with the communicable disease that is the subject of the emergency. 3 is to care for a family member who is isolating without an order to do so because of a diagnosis of the communicable disease that is the subject of the emergency. In each place where the bill references a diagnosis, I tightened the language up so that it would say of the communicable disease that is the subject of the emergency, to make
Right.
it explicit that it's just for the reason why there's a catastrophic health emergency.
Correct.
And 4, it's due to a determination by an official, public health official, that the worker's presence at employment would jeopardize the health of other individuals because of exposure to or exhibited symptoms of the communicable disease that is the subject of the emergency. And that's regardless of whether there's been an actual diagnosis.
Right.
5 is to care for a family member due to a determination that this is basically dovetailing with the prior one, but it's a family member who's been determined by a health official that their presence would jeopardize the community, regardless of whether there's been a diagnosis. And then the last reason is to care for a child or other family member when the care provider of the family member is unavailable due to the emergency, or if the child's or family member's school or place of care has been closed basically by government order or at the discretion of the school due to the emergency.
And I know that was a difficult one to swallow. Again, reminding everybody that this is going to be only taking place if there is available monies from the state or the federal. Because I know that was a difficult pill for most of us to swallow.
Mr.
And it
Chairman,
is
could you
only
go
for the
back?
14 days.
It's only for
Right,
14 days. Yes. sir.
Laura, could you explain again what you mean by this part of the bill is only effective if a federal state agency, is that paid both to private employers and the public sector?
So the state would have to specifically designate, or I guess, I don't know if appropriate is the correct term, but it's not a mandated appropriation in the bill. So that scope provision was added because my colleague in appropriations said that would make it explicitly clear that it's not a mandate in the bill. It's just setting up a framework so that if the state wants to direct funds to support this at some point, the framework is there.
And that also works for the private sector?
Yes.
For the private sector, an individual employer would have to have funds made available from the federal government or state government to provide the leave.
Okay, all right. I mean, we're still gonna have problems with doing that, but let me just ask you this question then. If the federal government provides monies available for leave the way they are currently, this wouldn't apply because the federal government's not giving the state of Maryland dollars to fund their own leave program. So it's not, so the intent of the legislature here is to not stack leave.
Did we put a preemption clause in here? Or did we take it out?
What do you
No,
mean?
this is
preemption?
this is in addition to the leave they earn under the
The
regulation.
FFRCA?
So there's a prospective application clause, but the state or federal government would have to specifically say, we have funds available for this purpose for employers that want to provide this leave to their employees. That step would have to take place.
So under that scenario, they could get the FFRCA and this if they identify additional funds for them to take an additional 14 days. But they have to identify additional funds.
So
And if the funds-
I was just gonna say, my colleague is messaging me from downstairs, and she said the governor would have to bring down a budget amendment to bring in federal or state funds for this purpose. The state brings in federal funds into the state budget through budget amendment. So this would have to be, there'd have to be a mechanism
Right.
that would occur in order for employers to be subject to the requirement in the bill. So I think to answer your question, generally, if this bill were to take effect in a few weeks, the employers would not all of a sudden have to provide this leave
Right.
That's correct.
That's correct.
because there would need to be a budget amendment.
Specifically for this.
So
But
they
it
only leave the bill, so they only leave the bill and imagines are the leave where you've got a worker who feels like they have to leave because it's unsafe.
Or they have to care for somebody.
Well, no, I mean, the only thing under the bill really is if under
It's,
the current right to refuse to work.
I meant refuse to work.
Right.
Okay,
There's
so
a
that
Okay, that's not leave. That's just refusing to work.
that's a separate, okay.
Correct.
Correct.
But that's
Separate
the-
section.
That's the current law.
And that's OSHA. That's already OSHA. That's why we kind of cut around the axle of something that already exists and we don't really need to redefine. They can already do all that.
So Laura, that's a novel approach. I'm not on appropriation.
It is a novel approach. At the last meeting, I said that's a seismic change. I've never
Mhm.
seen anything like it, but it's
I'm-
essentially setting the framework in place for funding to be provided for this purpose and
Right.
how
I'm
it
not
would
on-
be.
Yeah, I'm not on appropriations, but I would imagine a fiscal note for like this, if you guaranteed or mandated the funding, would be massive.
Only after they had, and I'm sure it'd be only after they had monies from the feds, or if they decided to do some crazy taxing structure. But we're going to assume that the money trickles down from the feds and we determine how to spend it. And this is the way the governor or appropriations determines how to spend it.
So my last question, and I'm not getting any, and I'm sorry, guys, I'm not getting any, this is truly an honest question. Really, the only way this portion of the bill will be applicable is if the governor proactively receives and asks for federal dollars and then makes this available through executive orders, is really the only way this comes about.
Or it probably does require the executive order, but again, if it's the federal government has instituted a program or of some sorts or whatever, and that the funding is available through that program, the governor would then do an executive order to say employers of essential workers, allow this framework of leave to go into effect and apply through whatever the name of the program is.
And for those listening, this doesn't preclude leadership and from chasing these other federal dollars and applying them in a different way. If they want to do emergency or hazardous duty pay or something of that nature, this bill doesn't preclude that from happening.
Correct.
We're making sure that this money would be made available prior to tasking the employers to pay it. All right, what's next? Laura?
The next section is all the different construction provisions that are mostly modeled after what's in the sick leave law. So employers don't have to compensate a worker for any unused leave. This doesn't affect any rights under, rights that would be more generous, or any rights under the workers' compensation law. And nothing would get in the way of an employer having a policy to prohibit abuse of the leave. So they can have a policy in place to try to curb abuse.
Right.
And then nothing prohibits an employer from providing additional public health emergency leave.
Right.
And then this is the documentation requirement in G. So an essential employer may require an essential worker to provide documentation of the need to use the leave. And if an essential worker fails or refuses to provide it, the essential employer may refuse to pay for the leave. And then the commissioner is required to adopt regulations about what forms of documentation would be appropriate. The next section of the bill that struck is the provision that required hazard pay and help with financial assistance with healthcare costs. I know Delegate Turner had previously had some questions about that. Did you have any questions about that?
Oh, this is the part, okay?
The hazard pay?
Yeah, the hazards pay. Did y'all strike that out, didn't you?
Yeah, we struck that out in its entirety. And what we did is we said that there is money coming down from the feds that we know that leadership
Yes.
will be pursuing. And that's, I said prior to this, that this bill does not preclude leadership, the governor and the speaker and the president from pursuing those monies and allocating them towards hazardous duty pay, additional bonuses for essential workers, things of that nature. This bill is not precluding any of that, because we do know there's some federal monies available, and this will not stop them from allocating that towards benefiting our essential workers in this current pandemic. Because this is
Okay.
also a perspective for other potential health catastrophes. We could not identify, we didn't have any monies to identify to keep that in.
Okay. Okay, but, Mr. Chair,
Yes.
the money is here, but it has not been allocated, right?
There is money coming from the feds. to
Oh,
the state.
also the money is not here yet.
Now, I'll let our chairman answer that, because I don't know where that money is. I'm not on appropriations. I don't know how that's going.
How's that going, Madam Vice Chair? Do you know?
Well, I think Derek, Mr. Chair is on the line. I think he'll be able
Oh,
to.
Mr. Chair, I didn't see you. Okay,
I presume we're talking about hazard pay.
Yes,
yes.
Stay tuned.
there you go.
Okay, that's a
Stay
good
tuned.
answer.
Ultimately, it has to come down from the governor. I believe something may be in the works on that, but I don't want to put it out there that, it's a done deal or anything like that. That would be premature, but that comes, that's beyond this committee's jurisdiction, in terms of that sort of thing, especially at that dollar amount. So, but I have been in contact with the chair of appropriations and speaker's office and so forth. So it's, I guess the best way to characterize it is that we're at a wait and see stand.
Okay.
But if something's going to happen, I think it's going to happen sooner rather than later.
Yep. And that's why our chairman gets paid the big bucks. Making
Does
those
that mean before, Mr. Chair?
It would
Does that
have to be
mean-
before we adjourn because
That's what I was
vote
getting ready to
on it.
ask you. Is
Yes,
that going to
because
be
we would have
before
to vote on it.
Saturday?
Yep.
Okay.
Laura,
Okay. I'll
Yeah.
stay tuned.
Yes, Chris?
while she's staying tuned, I just to say, I've never heard this before, and I've only been around for 7 years. So it takes an act of the governor to find and appropriate dollars to put this 14 days of leave. So I'm thinking of it like state employees and the private sector. The governor has to fund the additional leave.
In order for it to take effect, correct?
That's okay. All right.
Yes. It's an affirmative act.
Yes, I'm
Okay.
sorry, my colleague is sharing more information about how it would work. So I asked her if, what would happen if the General Assembly was not in session? And she said that the governor sends down budget amendments throughout the interim, and then the chair of appropriations and budget and tax approve them. And legislative services is, I guess, involved in the discussion about what to do with the budget amendments that come down during the interim. But it sounds as though there's a clear process and that it would take those official steps to occur before the leave requirement would be triggered on.
Okay. Thank you.
Okay.
All right, where are we at next?
This is the misclassification provision that last meeting, you all discussed changing the standard to say that an essential employer may not knowingly misclassify someone as an independent contractor.
Right, to avoid paying.
Mhm.
Right,
And then this section that's struck here is the enforcement provisions. So that is changed in the draft. So I went into it a little bit before, but there's sort of 3 buckets for the enforcement. The subsection A here is for the right to refuse statute. So this says that if an essential worker believes that an employer has violated that right to refuse provision under this bill, then an essential worker may seek enforcement of rights through the general MOSH right to refuse standard. And then the commissioner is required to respond in accordance with the MOSH enforcement provisions. The next subsection B says that if an essential worker believes that an essential employer has violated 31606, which is the leave provision, the essential worker is authorized to file a complaint. What you see below is has been brought over from the Maryland Healthy Working Families Act. That's the sick leave law. So it has the same sort of process for filing a complaint, having there be an investigation. The reason for not cross-referencing the sick leave law is the sick leave law has a private right of action, and this does not contain a private right of action. So instead, it's just sort of duplicated here, but for this specific type of leave. And then in subsection C, there's just a general provision that if an essential worker believes an essential employer has violated any other provision of the subtitle, the essential worker may file a complaint with the commissioner, and then the commissioner shall respond in accordance with the provisions of the MOSH law.
yep,
And then these are the uncodified sections of the bill. So Section 2 is not new to you all. That is the provision that requires MOSH to adopt the federal OSHA emergency temporary standard for COVID if one is promulgated. Otherwise, MOSH has to establish a specific standard for the state, an emergency temporary standard. And that would be a temporary standard. So it would expire at the earlier of the end of the catastrophic health emergency or the adoption of a permanent standard by OSHA. And that would have to be in effect regardless of whether the emergency temporary standard is subject to federal legislation. And let's see. So this also requires an employer to, this contains some specifications for what would have to be in the emergency temporary standard, such as notifying the commissioner and the Department of Health of positive cases. Let's see. Section 3 of the reprint says that the commissioner and the Secretary of Labor have to make available on the Department of Labor's website information reported by employers related to COVID-19. That is also not new to you all. That was part of the amendment that Delegate Valderrama had brought over from House Bill 124 into this bill. So that was in the prior reprint. Section 4 is new to you all. We discussed it earlier in the meeting. This is the section that requires the Department of Health, in consultation with the Department of Labor and local health departments, to develop a template health emergency preparedness plan. And the plan would need to be consistent with applicable federal and state standards and include a coordinated process for handling complaints and methods for raising public awareness about that process. And then in addition to the plan, on or before October 1st of this year, those same agencies would need to report to the General Assembly on recommendations for potential changes to the law to enhance their enforcement authority during a catastrophic health emergency.
And the reason we did that, guys, is obviously because we're talking about public health. The health department already has a great deal of power vested. So we want them to be the cornerstone of anything that's being created in the state as far as reporting, identifying, locking down any of these outbreaks. So instead of just a bit leaning on MOSH and Department of Labor, we wanted to originate it in Department of Health.
And the language that's currently in Section 4 says that those agencies would need to submit their recommendations about changes to the law if changes are necessary or appropriate. And my colleague in bill drafting pointed out that might make it seem like the agencies could say, we're just not submitting the report because we don't feel it's necessary. So, that it might be prudent to remove that last part there if changes are necessary or appropriate.
Let's strike that, please.
I think the language was intended to convey that if it's a value judgment by the departments, basically, whether they think changes need to be made to the law, but
no, we'll just
the
strike
General
it.
Assembly wants the report regardless.
Right.
Mr.
If
Chair,
that's your intent.
Yes.
okay, for brief discussion,
Yes, sir.
under B 2,
Section 4.
yeah, Section 4. This might fit the place where I was trying to say, is it possible to, in a plan, create an opportunity for, and I'm thinking food processors, but I could certainly be talking about manufacturer or large employers who would seek to get inspections and or pre-inspections of facilities to help them facilitate compliance with this law. And I might be wording this incorrectly, but the intent would be to try to help industry engage with the related departments that matter to them. So they're not only dealing with this defensively, but also, proactively helping industry work with the departments. So it's uncodified language, but the purpose of what I'm saying is to create a dialogue with industry and not necessarily mandates coming from top down. That's my thought there.
And I get your point. I'm not sure how we could word it because the part, you know, you brought up several times about the amount of work we're putting on these individuals already. So how do we word that without making that, like we say, reach out to non-specific agents, not agencies.
I mean, look, if
Include, I don't want to say conversations, include. What am I
dialogue,
looking for?
But
Not even
dialogue.
dialogue, include information gathered from,
information.
input's the word I'm looking for. Include input from business sectors
Different
that may
sectors
be
of business that are
affected,
possibly
Yeah.
affected by this.
right?
Okay.
So if you're including input, then some of the onus is actually on the businesses but if obviously are probably listening now and have been, you know, to know that they need to provide information to
Reach out to the health department.
these things,
Yeah.
Well,
putting this together.
Is that
actually, I think that gets pretty close to where I was headed because I didn't have anything in mind when I brought it up. The other comment I think is July 1st is going to come quick. So if there's a way to negotiate that time out a little further,
well, that was my big push only because we're still in a pandemic. If that seems unreasonable, I'm ready to listen. I just, you know, I really thought July 1st was just because of the pandemic issue. If you guys want to go to, what was the
How
original?
about July 30,
Here, August 1st. I don't, you know,
August 1st, I don't care.
I mean, another month. I mean, I don't want to go to November and I don't want to go to
Right.
January because we're still in a pandemic.
how about September 1st?
We're just so
And that's
far.
me negotiating with you, Chairman. That's not a,
I know. I'm just saying, just so far away, dude, because we're still in a pandemic. And this should be their main focus. The health department now, this should be what they're working on still. I'm hoping that, and again, we're assuming they haven't done any of this. I'm assuming they've done most of this. That's why I don't think this is a big ask, which is why I thought July 1st, because I'm assuming that they've been negotiating and dealing with this already, that we're not asking them to recreate any wheel. All we're doing now is tell them to codify what they've been doing.
All right,
Not
August 1st is in
codify.
the middle, not codify. Put
Not
it
codify, I'm sorry.
Yeah, put it in a document.
Put it in writing.
Yes, write it down. So let's do August
To
1st.
change the date.
There you go.
Let's do
We
August
need to
1st.
change the date.
That way we'll give them a little more time. Again, there's an assumption, and I think it's a healthy one. They're already doing almost all this. This is all
Yeah, I
information
agree.
at their fingertips. Okay? Is that good, Chris?
we met in the middle. Thank you.
Outstanding. All right, Laura.
Now, which one did you strike? E?
We didn't strike any of those.
Broke any of this.
Added
Um,
one.
What's in section 4, subsection A here, the template plan, giving an extra month to the agencies to get it together. So it'd be August 1st instead of July 1st.
Oh, I got that part, but I'm talking about before that. You said, Mr. Chairman, you said we're gonna take that out. Now, what did you say, take out?
I don't know. Oh, shit. Well, it was, about them being able to determine whether they want to respond to our, what was that? The line about them deciding whether or not they wanted to, give us their plan. Laura, remember?
Yeah, what was that? That was before, right? Before section 4, right?
What was it?
Or was it
There's
C?
a section of the bill as introduced that required individual employers to establish a health emergency preparedness plan. That we already covered that, but that was
That's not
struck.
it, That's not it, Laura. It's section 4, part C, last line.
Yeah.
Oh,
Yeah,
if
that's
changes
what-
are necessary or
Yeah.
appropriate.
Changes are necessary and appropriate because we don't want them to feel that they don't have to respond.
Oh, okay. I knew it was something you struck.
Okay, I got it.
Yep.
Yeah.
All right.
I
Okay,
don't let you go past me too fast now. Go.
We got it, honey.
I'm certainly not trying to go too fast, so please
Okay.
jump in anytime. Section 5 of the bill requires, this is again something that came over from Delegate Valderrama's amendments. On or before January 1st of next year, MOSH would need to report to the General Assembly on its enforcement actions related to COVID-19, complaints, site investigations, and information related to citations. Section 6 of the bill says that requires the commissioner to adopt regulations as soon as practicable after the bill goes into effect. And then section 7 is the application provision of the bill. So it says that the act, it shall be construed to apply prospectively and not interpreted to require an employer to, here's a typo, not interpreted, excuse me, to require an employer to provide leave for leave taken before the effective date. So I think there had been some discussion about, well, what if this goes into effect? Can an employee or a worker say, I took leave back in July that was unpaid and now I have this. I think it's less of a concern now that there has to be this affirmative step by the governor to have the leave be paid leave, but that was put in to make it explicitly clear that there's no retroactive payment for leave taken before the bill goes into effect. And then in B, the governor, it says, due to the declaration of a state of emergency, each essential employer shall provide the leave on the effective date of the act or on the date that the funding or reimbursement for leave is made available, whichever is later. So the leave needs to be provided when the funding is made available to the employers. And then the last section is just the emergency effective date provision, and then the provision that says the 2 temporary parts of the bill will sunset. And that is that.
Awesome. So, as I said, colleagues, I don't even know the procedure because I think there are a few amendments. So I don't know.
That's all. It's all one set of amendments.
Right. So if we just want to move, can I get a motion to move these amendments? When I needed them to do it. We need a Democrat to help me move these amendments, please.
So move.
Move the amendments.
And I need a second. Thank you very much. So on the bill as amended,
Move the bill.
is there a second?
Second.
Okay, all those in favor say aye or raise your hand. All those opposed?
No.
The regular.
Regulars, the naysayers. No,
That
thank you guys.
was 4-2, right?
That's correct.
Okay.
So thank you guys very much for all this hard work. And to my Republican colleagues, I hope you thought your voice was heard. And if you don't, it was anyway. So sucks to be you. We did pay attention to a lot of it, and we really appreciate Madam Vice Chair. Your help was amazing, as was Laura's. You guys have done a great work. I've got to go fix my hair before we get to session now.
No, it looks lovely to wear it just like that. Let me say too, I want to echo the words of the chairman. I know that this was a yeoman's task, and certainly not everybody got what they wanted, the whole, but that's rarely the case when you're dealing with bills of this magnitude of this. But we had, I don't know, and particularly you, Laura, you sat through we have 3 or 4 of the work groups before we got the subcommittee, and I didn't think you guys were ever going to stop meeting. It was definitely worthwhile and a needed discussion. And, again, we're not going to always agree. That's the process. But I appreciated everybody coming forward, giving an honest effort to, either make the bill better or give their opinion on how it could be improved. I just can't express my appreciation enough for the long hours you put in. Certainly, Laura, I was texting her and calling her over the weekend and all of that kind of stuff that you all don't see. And she answers every time. So maybe we can give one of them appropriation speeches or something. And I'd like to say, like the Academy, let me shut up. I need stuff.
Now you could have Laura back finally, right?
Now I can worry her about other stuff.
Right.
But anyway, guys, you got a few minutes. We got about a half an hour before we have to be on the floor. So I just wanted to say thank you. I wanted to stay out of you and let you all work, but I wanted to say thank you. So congratulations.
Okay,
thanks.
and we meet here when? Go ahead.
We're going on the floor at 5. I don't know if there's anything after that. 5 o'clock today.
And probably double sessions tomorrow and Wednesday.
Okay.
I hope that made your day.
Thanks,
Bye-bye.
everyone. Thanks, Chair, Mr. Chair.
All right, thanks.
See you guys at 5.